Hi, y'all, and welcome to tonight's live stream. Well, prosecutor Hank Brennan tore into Karen Reed's expert witnesses today in a fiery, very aggressive cross-examination outside the presence of the jury. It's all on the line for Karen Reed. We already knew that much. The ARCCA experts who were being cross-examined by Hank Brennan today were critical at Karen Reed's first trial. They were very professional. They had a deep technical knowledge, and they were originally hired by the Department of Justice, which meant that they looked very credible. They testified on the same side as the defense, for the defense, but they were originally hired by the Department of Justice. So they stood in really stark contrast to some of the witnesses put up by the prosecution. The defense portrayed those witnesses as botching the investigation, not very professional. And so the ARCCA witnesses, who they work for a company that provides expert testimony and does testing and so forth in the area of biomechanics, they were a huge part of Karen Reed's case in the first trial. Now the defense is trying not just to use them, but to expand what they have to say and what they do here in the second trial. So they could not be any more important. At the first trial, their job was to say that John O'Keefe was not hit by a car. And by their job, I don't mean, I mean that in the sense of that was their purpose for being there. That was the reason that the defense put them on, was to explain to the jury Karen Reed's side of the case that John O'Keefe was not hit by a car. Because if they're right, Karen Reed is not guilty. Just full stop. That's the end of the story right there. But now ARCCA has done even more. They had already done testing, or not testing, but they had already concluded that they believed John O'Keefe had not been hit by a car. Now they've actually done some new testing that can make Karen Reed's case even stronger. But the question is, will the jury ever hear it? Hank Brennan exploded on cross-examination, trying to block the evidence. He hammered the witnesses over missing text messages, undisclosed defense contacts with the defense lawyers, and the timing of the new testing. He argued that introducing this new data mid-trial is an unfair ambush. And frankly, he does have a point. It's usually a massive no-no to spring new expert testimony during trial. I mean, even now, ARCCA still doesn't even have a full report ready. The discussion today was whether they could produce it by the 7th, which would be yet more than a week from now. So it's not the first time these ARCCA witnesses have been controversial. The Commonwealth previously tried to exclude them altogether. But after a lot of very tense back and forth today, it seemed to me that the judge was leaning toward letting the ARCCA experts add this new testing that they've done. So we'll see. The only consequence so far to the defense, although there were very tense hearings and there were questions about sanctions against the defense attorneys, but in the end, the only real consequence so far has been that the defense wasn't allowed to mention the ARCCA witnesses during opening statements. And really, that was about it. But there's still plenty of risk. This is not a slam dunk for the defense. But if ARCCA gets in front of the jury and says what they said at the first trial, plus more, plus adds this new testing, it could truly be a game changer for Karen Reed. So special shout out to the first 5 tonight: Shiro Sheena, Michael Lalonde, Sky Goddess 87, Sunny Days, and Sweetie. Great to have all of you here, and great to have all of you here tonight. So usually the expert witnesses are kind of a slow point in a trial. They're pretty predictable. Everybody knows what they're going to say. It's very technical testimony a lot of times, but Hank Brennan just was all over these ARCCA witnesses, going postal on them. And he's not entirely off base, like I said. I mean, this is unusual to have in the middle of trial brand new testing be introduced would be extraordinary. But I think one of the most important points about what we've seen today is that this gives us a glimpse into what we have yet to come. Because if anybody was wondering, can Hank Brennan do a cross-examination? The answer is absolutely. Hank Brennan can do a really good cross-examination, which would make this trial very different from the first one if he is in charge of and doing a lot of the work on the defense experts and doing the cross-examination. So we will see what happens. So, okay. Let me talk a little bit about kind of how experts work so I can kind of explain the concept to you. And a little bit about how the whole system has kind of gone off the deep end and gone amok. So the purpose behind having expert witnesses is that some stuff is really complicated, and the more technology takes over in our cases, the more that's going to be a problem. So it's true that the jury may need this information, but they don't really have any way to unpack it. If all they get is, a binary code, they don't know what that means. So they need to know, okay, here is the meaning behind the DNA. When we give you these percentages, here's what this means. They need those scientific details explained to them so they can understand what exactly the arguments being made by either side are. So it became more and more important, I think, as science developed and as it became more and more a part of legal cases to need expert witnesses. But what has happened over time is that a group of experts have grown up around the need. And so there are many people who testify for a living. That's pretty much all they do in the scientific fields. And they become more and more specialized. They're usually very highly compensated, sometimes thousands an hour. Typically, they do bill by the hour. That's the way it actually ends up getting charged to the client. And what has happened in large part, and I'll just speak my mind on this, but it sort of swallowed the system with the expense because, I think it's gone so far that instead of helping the jury, it's kind of confusing because what happens is two experts come, one for both sides, whatever kind of civil criminal case, you get an expert from both sides. So one expert comes and says, here is what the science is. And the other expert comes and says, here's what the science is, the opposite. And I think it makes it difficult for the jury to have any idea what exactly the real answer is. And so, and the expenses balloon because now it's almost impossible to have a case. If the other side has an expert, you almost can't go without an expert. And that increases the cost exponentially in both civil and criminal cases. So that's kind of the lay of the land right now. And it's an awkward situation right now. It's sort of out of equilibrium, I would say. But to know these particular guys are very professional. This is their job. The ARCCA witnesses, they do this for a living. They were initially hired by DOJ. These are not yahoos. They know what they're doing. They are excellent at what they're doing. And they testify for a living in multiple cases. So they are very used to this. So I want us to start with what happened a little bit. Let me talk a little bit about where I'm gonna show you some clips, and let me talk a little bit about kind of where I want to start on that. So at the first trial, the defense attorney, Alan Jackson, told the court and the jury, yet we have not discussed ARCCA's testimony with the ARCCA witnesses. Okay, that is inconceivable in the world of law. I'm not even saying they were telling something falsely, but that isn't how it's done, right? Because this is incredibly expensive, and the case often hinges on this. So you better believe everybody has talked to every witness. They have been very careful about what they've made sure, what facts they have. They've gotten them prepared. It's just shocking. And that's why both the judge and the Commonwealth just didn't believe that. They were like, why don't you did too talk to them? And specifically, you're going to hear the Commonwealth, Hank Brennan, ask, now that they've had a little chance to unwind after the first trial and get a lot of discovery, they're going to ask about some of those things that they found in the course of the discovery. And one of the things they're going to ask about is a 40-minute call between Alan Jackson, the attorney for Karen Reed, and this particular witness.
heard the call on May 1st, 2024.
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation?
No, sir. And it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCCA, but never ever talked about this case?
Objection, Your Honor.
I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So yes, that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That old invoice, when it's sent, ultimately comes back to ARCCA. That doesn't come back to Dan Wolf.
Okay. So in order to get paid for that, you would have had to submit that time through ARCCA to then forward it, wouldn't you?
Objection, Your Honor.
Going to allow it. Is that true?
Yes, I keep track of my time so that my boss knows what I'm doing, yes.
Okay, so remember I told you how much lawyers are paying these witnesses. This is top of mind all the time, and it's almost always hourly. That's why that answer that, well, I'm a salaried employee, didn't really answer the question for Hank Brennan. The reason he kept pushing on this is he knows that ARCCA is going to bill almost certainly hourly when they send out a bill to Karen Reed or the defense, or DOJ when they were originally hired by DOJ. But this is such a weird situation, right? Because this group wasn't originally hired by Karen Reed. It wasn't really hired by the defense. It was hired by the Department of Justice when they were doing a separate investigation, which is why all of this is so confused. And we're going to talk a little bit later about what the defense counter arguments to this are. So right now we're going through what Hank Brennan argued and what he said, but we will get to the arguments against it as well. And you'll see some clips out of that as well. I want to say thank you to A to Z, who has been a member for 5 months. Thank you. I'm glad to have you along. So glad. And Jeremy Kelly is a new member and coming in strong, gifted 50 lawyerly memberships. Thank you, Jeremy. I really appreciate that. That's awesome. Appreciate that very much. If you are not a member, you can hit the join button down next to the channel name and join. It's a way of financially supporting the channel, but we have had so much fun. We have done a lot with it. We are presently writing a true crime novel. We've had a lot of fun with that. And we have live streams and just some things we do. Amazing emojis made by our own moderator, Marlon. So we have all of that. Those are all perks of being a member. If you are not a member, and be sure you have turned on the ability to receive gifted memberships, our mods will put into the chat how to do that. So thank you to Mama Pinks and Marlon, our moderators. All right, so let's talk a little bit more about, so the Commonwealth is also very upset about an outline that emerged in the discovery afterwards. Because remember, there was supposedly no communication between the defense team, the defense attorneys, and ARCCA and these witnesses. So how then, how surprised were they when they found this outline that came from ARCCA and went to Hank Brennan, or in that case, it was Lally. He was the prosecutor at the time. And it went to him, and it was an outline of what his testimony would be and questions he would be asked or should be asked. And the Commonwealth finds it really hard to believe that that wasn't the witness trying to help the defense. So you will see that more and more Hank Brennan is going to get really upset. You're going to kind of watch it develop as it goes. So that one of the things that bothered them as well is that this witness admits that he deleted text messages he had with the defense attorneys. He said he did it just routinely, but the Commonwealth believes there was something to hide. That was done in order to hide things and may have been even in disrespect of court orders or some kind of court duty. So let's listen.
So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right, was there 10, 100, 1,000? How many were there?
Of ones that I sent?
No, not just what you sent, either way, back and forth.
Probably, I don't know, maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial, sir.
Where were you when you were deleting this text? Were you at your office, at home? Do you remember sitting down and deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts where you
Sir,
were?
I just said I delete text routinely. You're asking me to specifically give you a location and a time when I deleted those? I don't recall that.
You said it was after the trial.
Yes.
Now, I'm going to say typically I would have expected an expert witness to keep those text messages and that information when you're right in the middle of two trials, because it was known right after the mistrial was declared, after the hung jury in trial number one, everybody knew there would be a trial number two. Granted, the prosecution might have decided not to go forward, but they made it clear pretty quickly that they were going to. So I am kind of surprised that an expert witness like this would delete these text messages. But he's also a very skilled witness too, talking about how he does this routinely. He doesn't have a lot of memory of anything unique about it because this was something he did on a very routine basis. So another thing that really bothered Hank Brennan is that this witness communicated with the defense attorneys using an app called Signal. That's I'm not familiar with the app, but it's an app that you use when you don't want to save messages. It gets rid of the messages so that they can't be found later. I will say I have not heard of that being a routine way that attorneys communicate with expert witnesses. Frankly, it will probably be done pretty soon if people haven't already thought about it, but I think it is pretty unusual. I think lawyers are usually attuned to trying to preserve things and preserve the evidence and so forth. So we'll hear Hank Brennan ask about that.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Sure.
You know the benefit of Signal, don't you?
I mean, it's a messaging platform, yes.
Well, it's an encrypted app, isn't it?
What was that?
Encrypted?
I don't know, sir.
It keeps no record of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal in your career is when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal. But this was at no point in time during the first trial.
Using the Signal app when
Let me stop it there. So this is unusual. This is unusual behavior. And you can tell that by the fact this witness has never done it before. He's a professional witness. He testifies all the time. This is what he does for a living. and he's never communicated with anyone by signal before. So that gives you an idea that this is really unique. This is not something that would typically be the way an attorney would communicate with an expert. That's not to say, though, that there's anything illegal about it, because I don't think there are any rules that would prevent that. But it's really interesting to see Brennan sort of bring this out and get more and more upset as we keep going. So if you would you mind hitting the like button? That'll really help us get the video out to more people. I'd appreciate that. And if you are not a subscriber, please subscribe. We would love to have you back for more videos. All right, so Brennan wants to know, and this is the question the judge has as well, did ARCCA expect to be paid by the defense? And the defense had said earlier that this was not, they were not paying these witnesses. They told the jury that. And so if they were expecting to be paid for the defense, and the defense did in fact apparently pay them a couple of months after trial, everybody involved in this is trying to figure out, was this all a sham way to make it look like these were unbiased witnesses when really you were paying them on the back end? You were about to pay them. And so that's what this next questioning is about.
You had a conversation on March 20th, 2022 with Attorney Jackson. You discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client, I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you. On March 20th, 2022, not the 22nd, not the 24th, March 20th, 2024, did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
So do you see how he doesn't really want to answer that question? He wants to kind of not answer it. He does ultimately say that he was, well, you'll hear more, but he does say that he was not expecting to bill them. And he tells the defense attorney, Alessi is the one who cross-examined him, and he says that he kind of thought that the DOJ might be going to pay them. And they just were kind of unsure what the ground rules were, since they had initially been hired by the Department of Justice, not by the defense attorneys. How exactly would this work? Tina, thank you so much. I appreciate your super chat. And Liz M has been a member for 14 months. Awesome. We are very close to 200,000. Thank you, Liz, for putting that in. And if you aren't a subscriber, please subscribe. You don't have to be a member to subscribe. You just hit the subscribe button. All right, let's keep listening. So what the entire goal of the cross-examination by Hank Brennan was to show the court that these people are really defense witnesses. They can argue that they're neutral. They can pretend that they are hired by the Department of Justice, but really, Hank Brennan is saying they're defense experts, and they have been all along. And he's starting to get more upset.
So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case?
Not work with. We could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an advocate for the defense?
Sustained.
Do you feel like you're an advocate for the defense?
No, sir.
Are you sure about that?
Sir, I'm on the science and the analysis that I've done. That's
sure?
the side that I'm on.
You sure are. Because after that 424 call letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had permission they could use you as witnesses.
Sir, there were never any.
So let's stop there. So this particular witness, and all expert witnesses, are used to being on one side or the other. I mean, they're hired by one side. And in truth, this witness really is a defense witness in this case. This witness may not have been hired initially as somebody who was hired by the defense. He may have been hired by the Department of Justice. He may be more unbiased as a result. But in terms of his function in this case, he's a defense expert. That's what he's doing. And so he made recommendations he did what he would classically do when he is hired on for a case, which is he tries to be helpful. This is his job. So he will make recommendations. Here's what I should probably answer. Here are things I should say. Here are categories you want to ask me about. Here are the most important things. Here's what to be worried about when the other side starts to cross-examine me. So he did all those things in this case. And now we're going to hear Hank Brennan ask about that.
Conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination. Sorry. When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue, I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides, you're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspected the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
That's two questions. Ask one question.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone in the argumentation.
Okay. So I want to stop it there for just a second and say, do you hear how his question was just, this is what you wrote, isn't it? There's nothing objectionable about the question per se. That did you write this? It's more the way he's asking it. And that's what, when they say argumentative, that's more what he's talking about.
Did you write that?
Yes.
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
Correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury. Yeah. That's what I was trying to make sure that that point was understood, to the jury.
In your collaboration with the defense, that's not all you wrote, is it? You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
I don't know if I understand your question.
Okay. Would it be?
Okay. At that point, I was like, oh, yes, you do. You fully understand that question. You don't want to answer that question. This is really good cross-examination. This is really good. And if Hank Brennan carries that over into the rest of the case, that means we're going to have some fiery cross-examinations during the defense's case. We didn't have any of that last time, so we'll just have to wait and see. But this is good cross-examination. So Hank Brennan is just trying to show that this is really a defense witness, and this will be cross-examination that I think they'll be allowed to ask in front of the jury as well, which is even before, when you were hired by the Department of Justice, you immediately jumped out and were attempting to assist the defense with what you were going to say. I don't think there's anything nefarious about it. I think he was preparing to testify. He knew that his testimony helped one side, which was the defense, and they were asking him to show up. And so he was preparing. I think that's just what he would normally do. I don't think it was something, but the cross-examination on this is really strong. So Nani Ann has a point that the police officers themselves did wipe a phone. And in fact, Brian Higgins, the ATF officer, removed and broke the SIM card from his phone, traveled to a military base and threw it out in a gigantic dumpster. So yes, he went to a lot of trouble to get rid of that phone, as did Brian Albert, who also didn't turn over a phone. So there's been more than one instance here. Truth and transparency. Hey, Lana, thank you for the super sticker. Good to have you in the chat tonight. And Megan, thank you for gifting 10 Lawyer League memberships. So we will have lots of new members. Marlon's going to be excited because we needed, I think, 23 more to get another emoji. And he had an idea for that. So hopefully after tonight, if people turn on their receive gifted memberships, hopefully we will hit that number and he will say thank you. All right. So the witness wrote about how he had done work on when he was writing that information for the defense before his first testimony. And it was questionable whether it even was received by the defense in time for them to actually use it, because it was like Sunday for a Monday testimony. But he was telling them, look, I've done some work on pedestrians and how fatalities rise at night just because visibility is so poor. So he's going to talk a little bit about that.
Fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians. You remember that one?
Yes.
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
Oh. And then, do you defer to the defense, not the jury, trying to give the full story to the jury, do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Well, let me explain.
No, I'm asking
So
you, did you defer?
Answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it and then you can give any explanation you want.
Hold on. Next question, Mr. Brennan,
You
and
said-
then you answer, Dr. Wolf.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because, for one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
So you can just kind of see where the cross-examination is going. And then don't forget, we are going to cover what the defense response is. I just want you to understand kind of where this part is headed. So the witness also talked, and this is, his name is Wolf, Daniel Wolf, in case you were wondering, talked about how many times he had testified when he gave testimony earlier before trial number one. And he told the defense, I think actually I said it wrong. I made a misstatement about how many times. And he asked, do you think I should fix that? Or what do you think
Question
about
31. Have you been qualified as an expert in court before? And you wrote back, yes. Remember that?
Yes.
And then you made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault, but in looking at my D&T lists, it's 11 trials and 7 depositions, 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you had made a mistake? Wouldn't you want to inform the court, I stated qualifications I didn't have, it was unintentional, but it was a mistake?
Well, that's exactly why I put the comment in there, sir.
You put the comment, you didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made the representations in front of? Did you let the court know that you made a representation that was inaccurate?
Again, that's why I put the comment in there to... Okay.
Did you inform the court about your misrepresentation?
No, I did not
No.
inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not. Correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
Okay, so the judge is a little impatient with this because it's very aggressive and he's sort of dwelling on some points. She's getting the point. She probably already is buying the point, but she wants him to kind of move along. He spent a little bit too long and she's getting a little bit impatient with that. So Megan had a good question. Megan Tomlinson asked me, do you think Hank Brennan was effective in this cross? He was so much more combative than the defense is. I don't think you can get more combative than Alan Jackson. Alan Jackson is phenomenal, but he is also very aggressive in his cross examinations. I mean, he is, but he is fabulous, absolutely fantastic. So we will see how this plays in front of the jury. He may have been a little harder on this witness, either because of sort of his emotional investment in this issue, because he's been fighting for a while to keep these witnesses out. And he's probably pretty upset about the concept of brand new testing being dumped into the middle of his trial when he doesn't even know what it is. He's already through with his case almost. Well, I don't know how long he has left, but 2 weeks into his case before he even knows what the testing is. That would be, I've never heard of that happening before. I've never heard of a judge letting it in at that late in the game. So maybe he's just upset about it. Or maybe he'll be like this in front of the jury. Maybe he'll be toned down. I don't know. I think it'll be very interesting to find out.
When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue, I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides, you're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspect the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your
Okay,
communications
yeah, I thought
with
so.
the...
We've heard that. We'll skip ahead.
Understand that because I did not physically inspect the vehicle, it did not matter for my analysis.
I
That
had-
was the point I was trying to make. Let
I
me
had
finish.
enough information from the material I reviewed, so it wasn't necessary. You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything.
Let's skip forward just
All right,
a
I'm not going to come to trial, not review anything, not look over my notes, right? It's something that I do internally so that
Let
I
me
can
back
have an
up. So what
understanding
we're,
how...
yeah, I wanted to make sure we get to the part
The
where
material I reviewed, so it
Unless
wasn't
he-
necessary. You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
All right, so now we've gotten to the point where the defense is going to do cross-examination or direct examination in this case. And here is what the defense has to say about that outline that he sent, as they let him explain a little bit more about why he sent that outline to Alan Jackson, how he thought it would be used, and about the fact that Alan Jackson never requested
Lines
it.
that you sent to Mr. Jackson. Did he ever broach in any way at all any idea of you sending him an outline?
He never asked, no.
Was there even any discussions that you might send an outline?
No, as I mentioned, it's something that for me is customary as I'm preparing internally for trial, right? I'm not going to come to trial, not review anything, not look over my notes, right? It's something that I do internally so that I can have an understanding how do I want to try to answer questions that might be posed to me such that I can have the jury understand how did I arrive at my opinions.
Was it important to you, before you sent that email with those outlines, was it important to you that the jury got a fair and accurate presentation of the work you had performed in association with your February report?
Yes, I think that that's my job.
was there any other motivation that you had in sending that outline in that email to Mr. Jackson other than making sure testimony was elicited that would make your perspective clear to the jury?
No, that was the only reason.
Were you trying to in any way favor the defense, give the defense any favor with regard to that trial?
Absolutely not.
Remember the call on May
Let's
1st?
stop it there and pull that out. And there we go. So some of the other arguments the defense made, I mentioned a minute ago about the Department of Justice being the original hiring entity, that they're the ones who hired ARCCA to do this investigation and reconstruction of the incident where John O'Keefe was killed. And in this particular case, the witness said he really had expected that the bill would go to the United States Department of Justice. And I guess they had a problem with paying for testimony in a private criminal case, not even in federal court. So that must be how it came about that the bill ended up going to the defense. So I think it would be fair to say that that ARCCA was clearly anticipating being paid, but it was maybe a little bit vague as to exactly who would be paying. And according to the witness, he thought DOJ would be. He thought the federal government would be paying, not the defendant, and not Karen, in other words, not Karen Reed. So he also, they also talked about the fact that the defense had not tried to change any of the testimony. It was frozen in time when they prepared their report for the federal government. Once that was done, this was their opinion. Now, of course, they're going to have new opinions if the judge allows them to present this report and if she allows it to be used at trial. And she did mention it at the end of the day, like, you could get that done by May 7th, something like that. So it looked to me like she was considering allowing this and letting them do this. So just a few other things. Let's go a few other things that happened today. There's one thing in particular I want to tell you about. We heard from Ian Whiffen. He testified last time in a much more limited capacity. He works for Celebrite, and they are the company that does a lot of the background programming that allows them to extract from a cell phone. And it was used to extract from Jen McCabe's cell phone. It is what had that hostile to die in cold at 2:27 a.m. Remember, that search was pivotal in trial one and will be again in this case, of course. So Jen McCabe, according to the defense theory, Googled this because she knew for a fact that people inside the home at 34 Fairview had harmed John O'Keefe, dragged him out to the road, and left him there to die. And she was wondering how long it would take. That's why she would Google that at 2:27 in the morning, because at 2:27 in the morning, she hadn't yet been contacted by Karen Reed. She hadn't gone looking for him with Karen Reed. She had no clue he was sitting there perched in the corner of the yard. She didn't know that. And so how could she possibly have done this search at 2:27 in the morning? Huge bombshell fact thrown into the first case. Very important. But according to Celebrite, which is the company that Ian Whiffen works for and that creates the background programming that allows them to pull this out, the timing of 2:27 a.m. is actually incorrect. It's not that it was incorrect, is maybe not the right word. So here's what he explained. When you open a Safari or Chrome or something like that on your iPhone, when you open that window, it records or logs the time that you open that window. So if your first search is, Lawyer Lee tonight or whatever, whatever you're Googling, then you would search that. And if you go back into the search bar and search another item and another item, they're all marked with that initial time. So it would look like all of them were searched at that initial time. Now, if you close that window, if you go to another window, then it starts over again, or if you open a new window. But for the period of time when you are looking at, when you are still in that exact same window, then you get the same time. So according to the witness, Ian Whiffen, that initial search was some other completely innocuous concept. And then at 6 o'clock, a little bit after in the morning when the body had been discovered, that's when she was Googling how long to die in cold, and she misspelled it. But so that was pretty much the entirety of his testimony at the first trial, but he has a lot more that he is going to talk about this time, or did talk about. It's already in front of the jury. And one other point on that, Celebrite actually removed the timestamps, they said, to, quote, avoid confusion, because apparently this is not the only case that had this issue come up. So one of the other things he talked about was the flights of stairs that John O'Keefe supposedly took. The defense says he took 3 flights of stairs, and that's because he entered the home there at 34 Fairview, which required going upstairs. And how else can you explain him taking steps if he's dead in the front yard? Then how do you even explain that? So Ian Whiffen went through a chronology and did a map and concluded this. He said that the phone can register a flight of stairs when a person's driving, and that the timing of it, and he wove it into exactly when the timing had been in terms of where the car was moving, that you could see that he was in a car on an incline steep enough to trigger the phone to believe he was climbing up a flight of stairs. Now, the defense says that it's complete and total nonsense. So we will hear all about that when we get to the defense case. He also talked about location data and said that it was very, very accurate so long as John had the application Waze up, which honed in the exact location. But at 12:24, John O'Keefe was at a complete stop. So he's right near the flagpole, according to where the phone location is. But at 12:25, he closes that Waze app he had been using as his GPS to get to the home. They were driving to the home, maybe didn't know where it was. He had the app open, so he closes it. And at that point, according to Whiffen, the accuracy is reduced. And he said it's a reasonable assumption that O'Keefe never moved from the area near the flagpole. So there wasn't a lot of clarity around that. The cross-examination was pretty good on this, talked about the portion being omitted that had been in the report but wasn't in what was shown to the jury today, that said that O'Keefe's phone at one point was moving west toward the house. Now, he was found somewhat west of the flagpole, but he wasn't very far west, and he was nowhere near as far as the house. So if he had gotten as far as the house, that's huge for Karen Reed's side. And then finally, and this is where I want to show you, share a document with you. One of the things he talked about was the battery of the phone. Now, this is new from the first trial, and it's really interesting. You can see this is a graph he showed to the jury, and you can see the initial dots, the red dots, are all on the left. You have Celsius, and on the right you have Fahrenheit. So I can never figure out Celsius, but for those of you who are metric, you'll understand that. And for the rest of us, you can see that for a significant amount of time, all the early hours, then it was in between 77 and 88 degrees. This is when John O'Keefe is carrying his phone around in his pocket. He's in the bar, it's warm. He's in the car, it's warm. So it's a pretty steady warm as it's being carried next to his body in his pocket. Then at 22 minutes after midnight, and moving until 37 minutes, and that gap, it begins to drop. And it's pretty much a smooth drop until 1:36 a.m. You can kind of see that big drop. Then there's kind of a lot more gradual drop. I don't know if you can see I think, there we go. So right there, you can see all of a sudden it's a lot more gradual drop. And it only moves down to, I think it was, I don't know, maybe it looks like 44 degrees Fahrenheit, something like that. And then there's a little bit sharper drop here. Now, the suggestion by the Commonwealth is the reason for this sharper drop is his body is being moved around as they're trying to work on him and give him CPR and address his problems. They're trying to do that. And they move him around, and maybe the phone gets exposed to the cold. So you have a sudden and very quick drop in temperature. And then somebody picks up the phone, and you can see it immediately goes back up. You can see it's just kind of a straight line upwards as it's warm again. It's taken in a car. It's being carried by somebody. So it starts to move back up. So that's really interesting testimony. We know, but don't have any explanation for it yet. The defense has said they believe what you see right here is evidence about their exact theory of the case. I don't know how that'll work. We will find that out when we get to their case. But the Commonwealth explanation seems to fit pretty well, although I am a little surprised about how little change there is in this long gap there as we move from 1 o'clock, 1:30, all the way to 6 o'clock. There's not much. Now, I get that it's underneath John O'Keefe's body, and so it's touching the ground underneath him, and then it's touched by his body. So you would expect that to stay a little bit warmer, but I'm still surprised that in the middle of a blizzard like that, it's not more, it doesn't drop even more than that. So anyway, I'll be interested to see what the defense argument is as to what it is. Now, as far as the time of death and the end of the phone use, the witness also said, and let me pull that out, that the time that at 32 minutes after midnight, there were 36 steps. And then that's it until the next morning when somebody else is moving the phone around, that there's no evidence that anything happens in the middle of that time frame. So the defense pointed out, well, that's just 7 seconds after it was locked. So that's not a lot of time, maybe even to do 36 steps. That seems pretty minimal. And the defense also pointed out that there were 2 text messages from people inside the house as he was about to go in, that from Jim McCabe and Brian Higgins. Naturally, we will hear a ton more about that when they come and actually testify. All right, I think that's it for the recap. Let's do some questions. And first, I need to say thank you so much, Matthew, for gifting 20 lawyerly memberships. Thank you for doing that. I appreciate that very much. And ITM, thank you. I appreciate your super chat. And Mildred actually, this is funny that you asked, Mildred. Do you think the jury will check their phones to see if hills are lodged as stairs? Does that count as research? It 100% does count as research. But I almost went out. We have a huge hill in our neighborhood. I was going to drive up and down, filming my phone. I haven't gotten around to it yet, but I was like, I really want to know about that. Like, does that make sense? Because it seems like it would not record that, but who knows? If it's hold in your hand, maybe you have to be driving a certain speed. Anyway, it's funny that you asked that, Mildred, because I really was thinking about doing exactly that. Oh, I forgot to say, if you would please put your questions with question marks at the beginning. That'll help me spot them in the chat. I switched streams twice. I don't know what, I didn't mean to, Michael. I don't know what I did. All right, Judy Ann asking me, it seems like Brennan does not care if it's a fair trial. He just wants to win. And that's not justice. Completely agreed that particularly the prosecutor has to constantly be aware of justice. But I don't feel like he's veered into the unfair. I feel like he was pretty emotional today. I had no idea we would be seeing this. I mean, he seems rather reserved, right? So I was really surprised that at the cross-examination, it was outside the hearing of the jury. So we'll see what happens when he's in front of the jury and doing a cross-examination. Very curious. Bonbon, are you surprised that the judge let Brennan be so disrespectful to Dr. Wolf? She seemed to reel in AJ when he gets a little spicy. So I think that she did reel him in a couple of times. He was, maybe she was surprised too. Maybe she was as surprised as I was. Maybe that's not his normal character. And so she was kind of taken back, like, well, we'll let him run with it for a minute. But I think it helped that it was outside the, it was not in front of the jury. It was outside the presence of the jury. So I think that probably made a difference. I mean, I definitely think that she tends to favor the prosecution. I don't think there's, a huge mystery in that. I don't think there's any surprise in that. You can certainly see that the number of rulings, the weight of the rulings is more in favor of the prosecution than in favor of the defense. Okay, elevate the process is asking, will the attorney allow ARCCA's new testimony? So I don't know whether the judge is going to allow that or not. I did not see an answer to that today, but we will find out really soon, I feel like. Texas 2 Pugs, why? And I feel like she will, because of her question toward the end about, so you could get this done by May 7th. I mean, that pretty much opens the door and says, I'm thinking about letting this happen. Texas 2 Pugs wants to know, why was this witness questioned outside the presence of the jury? That is a great question. And the answer is because the judge is trying to make a decision about whether to let this testimony in. And she hasn't decided yet. So the question is, will they be allowed to do this additional testing and submit that and then talk about it in front of the jury? Is that going to be okay? Will she agree with that? And she hasn't agreed with that yet. So this presentation was about that issue. The defense was arguing, yes, we should be allowed to do that. And the prosecution is arguing no, and they've abused their duty to produce stuff to us in the past, and therefore they should not be allowed to do anything more. Okay, so let's see. I'm looking. Okay, here's Mal O asking, how might Judge Canoni limit ARCCA if she continues to find they misrepresented their relationship with the defense? I don't know that she has a lot of options. I can think of 2. One option is to say, okay, you can't testify at all. And she's pretty much ruled that out because she's going to allow it, as I understand it. I think she's going to let them testify. The second thing she could do is say, well, you can testify to all of the things from your federal report, but this brand new testing that you haven't even disclosed to the other side, that you are not allowed to use. So those are the 2 things that I can see that she might rule, and we'll just have to wait and see what she actually rules or what she permits in front of the jury. Peppermint wondering, if you were Karen Reed's attorney, would you suggest she do TV interviews and documentaries? So, oh, Peppermint, such a good question. And honestly, I think my mind is changing on that. I've said that I feel like if she had not made this a really big public plea and talked about the abuses in the investigation, the lack of investigation, as well as the abuses by Trooper Proctor, that a lot of things would be different, including the result for her. But wow, has this hurt so far with those 11 clips, 10 of them really, but they've been numbered 1 through 11, but number 6, I think it was missing. So those clips have been really, really damaging for Karen Reed. So I think the answer is no. I think she should not do TV interviews or documentaries until after. And of course, by then it's too late to help her, but at least hopefully also too late to hurt her. Okay. So, but that doesn't mean somebody shouldn't be doing it, because somebody should be talking to the media, in my opinion, because otherwise, in this particular case, the information they have that they believe shows a cover-up, that no one would know that. It would be completely under the radar. And I think that would have minimized some of the effects that she received, including some of the effects with the federal investigation. Serene Allen, I wonder if the temperature of the phone was gradual because snow is insulating. So, okay, this is what I understand, Serene Allen, is that it was, that's still possible, but it was under John O'Keefe. John O'Keefe was on top of it, and then the snow was on top of John O'Keefe. So yes, possibly, maybe that had something to do with it. And I guess the ground, you would just think the ground would be completely frozen. You would think the ground would be 32 degrees pretty much. I don't know. I will be interested to find out. When I was in Boston, my view was that the ground was 0 degrees all the time. It was very, very cold. All right. So looking for those question marks at the beginning. Here we go. Olivia's mom. It would still count steps if it was in his back pocket and being carried out. Yes, it would. It would still count steps. Because I know mine does. So definitely I agree with you, Olivia's mom. Are they calling the man who started the whole story of a fight to Yannetti? Neely asks. You started the whole story of a fight to unity. I don't know who that is, Neely. You know something I don't know, so I can't answer that question. Sounds certainly very interesting. I don't know who did it though. Cynthia, why is it okay for the judge to favor either side? It's not. But okay, so it's not okay for the judge to rule unfairly, but for the judge to have an opinion, ideally, no one would be able to tell what the judge thought. I personally consider it a high honor when people will write, "Oh, you're so biased for the defense." And in the same set of comments, someone writes, "Oh, you're so biased for the prosecution." Like, thank you. That shows that I am not biased in either direction. That's what a judge wants to aim for. But there are rulings that are discretionary where the judge just gets to decide. It's not something where it's a clear answer in the law. And in this particular case, those tend to seem to go in favor of the prosecution. So the Commonwealth, that's what I'm saying. Okay. And DJ asks, what? That's me all the time. What? Wait, what did I miss? All right. Elizabeth, the defense was going to be hiring ARCCA. Wouldn't most conversations be attorney work product and privilege? A signal chat wouldn't be improper in that case, would it? When an expert has been hired and is testifying, then a lot of communications open up. It depends. It's, case by case. There has been a change in the federal rules of evidence that permits more protection for some of those documents and discussions. But in general, it opens up some when an expert is going to testify, and these experts are testifying. All right, let me head over here. Okay, looking for question marks at the beginning, and there we go. Jen the Couch Fairy wants to know, I think she's going to exclude the original reports and work they did for the DOJ. That would be, if she did that, that would be an enormous ruling. I don't think she's going to do that. That would be huge if she actually said that they couldn't even talk about that. I think she's going to let that in. I don't know what she's going to do about this extra testing, but it sounded to me like she might be going to let it in. To be honest, I would have a problem with that if I were the Commonwealth, because they've already given opening statements. They've had all these witnesses, and now suddenly they have to adjust to brand new information. They don't know what's going to be in this report. So she may rule with them on that. I would not, that's not irrational for her to do that. Now, the defense argument is, well, it's not like we could have given it to you earlier because you didn't give us information until end of January, beginning of February. So we didn't have a lot of time. We got it done within about a month, the testing, and now we're writing up the report, and that's about as fast as we can go. It's your fault for giving us your information late. So we will see what the judge does about that. Thoughtful Rebels wants to know, how do we know the phone didn't just get thrown in the snow or dropped? That is a really good question, but I think we had an answer to that in the first trial. I don't think we have an answer to that in this trial. We might. Yeah, I think we do. I think Carrie Roberts said it was on the ground and she went over and picked it up. So I think that's how we know that it was underneath the body. JD is asking me a question I've really been wondering. Do you think the state has more videos they will be showing? One thing we've noticed is they've been very strategic about when they were putting in these video clips from the interviews that Karen Reed has done. And they've had a very big impact in large part because of where they were placed. So I think they will have some more. I think they're going to want to put one toward the end. He seems to have a lot of sense of pacing. And so I think we'll find something dropped in at the end. And if he has more, he'll sprinkle those throughout. It would seem like he wouldn't use them all right at the beginning. All right. Well, tomorrow night we will be live at roughly 7 p.m. Eastern time, and I will look forward to seeing you then.